Tonight, NPP minority takes its war against oral committee a notch higher, charging former NPP government appointees to disregard the mandate of the committee and refuse any invitation from its members.
A former government official and we're invited by this so-called oral. Our advice to you from the minority is to boycott any invitation from the oral team.
We have details as the group describes Attorney General nominee Dr. Ayine as deeply embroiled in conflict of interest.
In the case of the Attorney General and Minister for Justice, the Honorable Dr. Dominic Ayine, it is clear he finds himself in a conflict of interest position.
We delve deeper into these allegations and more here on Top Story, brought to you by Telecel, Connecting Energies and Holy Insecticide Spray and Coil. Enjoy a holy sleep. And tonight, the opposition NPP group in Parliament are taking the war against the Operation Recover All Loot Committee a notch higher as it charges appointees of the Akufo-Addo administration to disregard the mandate of the committee. Now, the NPP minority have described the oral committee chaired by Samuel Okudzeto-Ablakwa, North Tongue MP, as unconstitutional and one that is without any legal basis at all. Addressing journalists in Parliament, MP for Swami John Dako, who spoke on behalf of the minority, asked former government officials to totally disregard any invitation from that committee.
The Attorney General designate is a law professor. When approved, he is going to be the chief enforcer of our laws. When he appeared before the committee and was asked about the legality of this oral, he justified the unconstitutional establishment and putting together of people who go about harassing former government officials. We believe that the establishment of that oral committee violates and flies in the face of our constitution. And so one would have expected that a law professor in the person of Dr. Ayine would have condemned it, but rather he justified it. Now his justification is now putting the work of the police CID, IOCO, and special prosecutor and constitutionally established bodies out of business. It is concerning, and we want the people of Ghana to know that no serious country will entertain anything such as this. And so if you are a former government official and you're invited by this so-called oral, our advice to you from the minority is to boycott any invitation from the oral team. We are not going to be part of it because we believe that there are constitutionally established bodies that can investigate any so-called misdeeds of the government. What are they doing? What they are doing is to go about disturbing people, entering homes, taking vehicles, seizing vehicles, and more or less taking over lands from people who have genuinely purchased land.
It will be recalled that at the vetting of Dr. Dominic Ayine, the issue about the oral became quite prominent, with the NPP insisting the oral committee has no lawful basis, but the nominee disagreed. Supported by Mahama Yarga, the two NDC MPs cited constitutional provisions to back their position that the oral committee is actually grounded in law.
There is nothing about oral in Cmttee. Now, the question whether oral is legal has been raised, by various people within the media, right? Oral is the Operation Recover All Loot. If you look at the preamble to the Constitution, it is very, very clear about what are the fundamental values underpinning the Constitution. The value of accountability is one of the preambular commitments in our Constitution. It's a primary value. Oral is supposed to exact accountability from persons either politically exposed or persons holding public office who used or misused their office to loot public resources by way of property, money, and other intangible resources. So oral is constitutional. Oral is legal. In fact, the fact that it is a non-legal body doesn't mean that it is illegal. There's a distinction between non-legality and illegality.
So if somebody forms a committee to elicit information about instances of looting of public property and waste and resources, is it not to provide an avenue for compliance with this constitutional provision? Is that not what it is?
No, we are.
And how different is this campaign from the campaign that took place recently? See something, say something. If you see looting, say it. If you see stealing, say it.
Also, you had the Attorney General and Minister for Justice designate Dr. Dominic Ayine and Boko Central MP Mahama Ayariga. Well, thankfully, we have been joined on the phone lines by Martin Pegbu, who is a private legal practitioner and member of the Operation Recover All Loot Committee. Grateful to you, Martin Pegbu, for joining us here. Now, first, how have you and other members of this committee been receiving the challenge of the legal basis of the committee of which you are a member of?
This is how we see it. You see, in the book, The Republic by Plato, Socrates is reported to have said that an unexamined life is not worth living. An unexamined life is not worth living. I mean, in current modern political discourse, they'll tell you that it applies to citizens holding leadership to account. Yes, so we see it as citizens who are asking questions. And so when we answer, it helps the political discourse, it helps in our development, right? We don't feel threatened at all by the questions they are asking because it's a bridge. It's in there, or maybe I should refer to it simply as Kujo, right?
Yeah,
it's in Act 720, the Whistleblowers Act, that if you see any crime or a civil wrong, you can choose to go to the police, Yoko, etc. Or you can go to your member of parliament, the MD of your company, or if it's not an MD, the head of your institution. You can go to your chief. You can go to your head of family. So if you see Minister X has $1 million under his or her bed, instead of you going to the police station straight, the Act 720, the Whistleblowers Act 6, you can go and inform your head of family so that your head of family will then choose to go with you. Or if you don't want to go at all, he can go alone. When it comes to crimes, etc., it's not always the owner of the thing that is stolen or destroyed or the subject of the crime.
Do we need a committee for that based on the education you are giving us?
Absolutely. Absolutely. Don't the English say that too many chicken don't spoil a broth, right? And I'm doing saying quite Okujeto Ablakwa is an MP. And so if we are all helping the exercise, I don't see anything wrong. You remember when President Akufo was in office, he set up the Office of Accountability as President Akufo. At that time, the police were fully functioning. We had Iyoko. We had Shrad, etc. Yet President Akufo set up the Office of Accountability, right? Yeah, so it's always been there. Kojo, let's read through the Act 720. It helps so that other persons will be encouraged to go and buy copies and see. So it says that under Section 3, it says if you're wrong, an impropriety, and you don't want to go up yourself, you can report to any of these persons. So let's go through quickly. It says persons to whom or institutions to which disclosure of impropriety may be made. 1, disclosure of impropriety may be made, and when they say impropriety, it includes crimes, may be made to any one or more of the following. A, an employer. So at Joy FM, there's a Kwesichum, there's the other one, okay, all the various heads. It says an employer of the whistleblower. So could you can choose to go and inform Kwesichum instead of going to the police station. B, a police officer. C, the attorney general. So you've seen a crime, rather than go to the police station, you are going to the AG himself or herself. D, the Auditor General. Can you imagine in the days of Domlovo? E, a staff of the intelligence agency, so NIB, National Security, Immigration, etc. F, a member of Parliament, Honorable Okudzeto Ablakwa. J, the Serious Fraud Office, now IOCO. H, the Commission on Human Rights and Administrative Justice. I, the National Media Commission. J, the Narcotics Control Board, now Authority. K, a chief. So you can go to Asantehene. You've seen a minister taking money. Instead of going to the OSP, you choose to go and seek audience with Asantehene so that he will take up the case. L, the head or elder of the family of the whistleblower. Let's repeat. The head or an elder of the family of the whistleblower. Then you go to M, a head of a recognized religious body. So you want to go to your pastor. N, a member of a district assembly. They didn't even say the district chief executive yet. Who come to the DC or MC. But it says a member of a district assembly.
Okay. Now the charge to former NPP appointees is to disregard your mandate. How do you react?
From what I've just read, it's obvious that it doesn't help us as a nation to disregard our mandate from the list. You see, we didn't even have enough time to exhaust the list. So it's obvious. As I've said, the reason I will not use negative words on their cause is that we are building a democracy together. You remember a few months ago,
sure.
Yes, I was all over radio asking Akufo-Addo and Bawumia tough questions. Yes, so that's the same thing they are doing. So to the extent that Akufo-Addo and Bawumia didn't shut me down, it will look very odd that at this time I'll begin to say people should shut up. No, it would not gel. It just would look too bad for our democracy. So by all means, let them ask all the questions. That's what Socrates said, that citizens also should be involved in the democracy. The more they ask questions, then the better the outcomes, because we'll be careful. We haven't invited any persons at stage one. It's phase one. But if you read the NDC manifesto, which the people of Ghana thought was better and voted for JM, they said there will be stages. So after the phase one, where we are collecting evidence, etc., there will be stage two, where we would go on to help the law enforcement agencies directly. And the OSC issued a statement yesterday in the half yearly report. They said they are going to work with oral because that is law.
Okay.
But as I said, let the minority ask questions. It makes our democracy better.
Do stay with me. We also have on the phone line MP for Swami, John Dako, who actually addressed this part of the NPP press conference earlier today. Grateful to you for joining us, John Dako. Is there something the NPP is afraid of regarding the work of the oral committee? Because of it, you are insisting that it is illegal when actually it is explained to you on several occasions that they are simply gathering facts to be presented to the NSAG.
Okay. Thank you, my brother, and regards to all our dear listeners. I've listened to my brother, Mr. Pebu, on this issue, and I'm surprised that he goes on and on and on with the Whistleblowers Act. If you look at the law, clearly, the law on disclosure is clear. Section 3 that he read, it lists a number of people, an employer of whistleblower, like he said, a police officer, an AG, auditor general, a staff of intelligence agency, a member of parliament, serious fraud office. Everybody should look at section 3 of the Whistleblowers Act. Now, if you take Honorable Okudzeto Ablakwa, who is a member of parliament, and so if anybody feels that some crime has been committed, it can go to him. Let's ask my friend, my learned friend, does he fall into any of these categories? Is he a member of the National Media Commission? The former police officer, Akufo-Addo, is he a member of the Narcotics Control Board? Mr. Domlevo, is he a member of the District Assembly? Is he a chief? Is he a head of any institution? Is he a head of any recognized religious body? The Whistleblowers Act he's talking about has the people you can disclose an information to, not a group of people set up by a president. In any case, what formed the basis? And we've made this point that when now His Excellency the President John Dramani Mahama set up the Oral Committee, he was the president-elect. He did not hold any executive authority.
Okay, but back to my question
what
about
legal authority did he have to set up the ORA in the first place?
Okay, I get this.
So when we say that that committee is unconstitutional and is illegal, we are saying that because from the start, from its foundation, it had no basis.
Okay, I get it, but I'm only asking that. If there is nothing to be afraid of, why does it hurt if a government says I want to form an oral committee to help me gather information on people who have looted from the state?
Wow. I am shocked that anybody will ask this question because you see, we are a country of laws. We are a country governed by laws. So unless there's a law backing such activity, we cannot take it for granted. Today is person A, tomorrow is person B. Everybody in this country, including the president, must act within the law. Okay, so you cannot say that because you are not going to be affected, you allow the illegality to go on. Of course, the members of the minority group who held the press conference, we are not afraid of any oral group. We are not afraid that anybody will come to us. And I also believe that no former government official is afraid of this group.
Okay.
But what we don't want is a situation where bodies are set up to harass people.
Okay.
Now, people are going into homes of former government officials in the middle of the night. They are going to their lands, they are going to their houses, pulling buildings down, taking their vehicles, all in the name of ORA. Something which has no legal basis.
Okay.
We are saying that if we are serious as a country, we have institutions to build, we have institutions to protect. You have your CID, you have your the YOKO, you have your the special prosecutor. You have all these institutions. If you really are serious about fighting corruption, go to them. What is the legal capacity of Martin Tebu to be receiving information?
We
should ask ourselves. If you look at the list he himself gave, does he fall into any of these lists? Any of the list here?
I get it. I get it, John Darko. I'm grateful to you. But stay with me. Let me bring in Martin again. Martin, if you should invite, you should invite anybody, because you say that the second phase of it will be to invite people. If you invite someone and the person does not turn up, what will you do? Do you have any legal basis to stand on to then take any further action?
Oh, the invitation, as I said, we haven't reached that yet.
Yes.
So by the time we get there, as I said, we are going to be working with the established institutions.
Oh, wow. Now you're not going to work with an established institution.
It's not like
what stopped the president from using the established institution from the
manifesto that was brought out says that they will do necessary amendments to make sure that ORA works with the establishment, the established law enforcement agencies. Okay, and let me quickly correct the Honorable Mr. Darko. The list, as we read in law, is not exhaustive. No, that's not exhaustive. So, even going to the head of family, etc. What you see, what Mr. Darko is doing? Can you imagine, Mr. Brace? This list is saying you can go to your head of family. So, if you are coming to people who is nearer the law, a lawyer, helping you to go to the institution, even between the two, a head of family who is not a lawyer, maybe does not even want to interface, doesn't even like going to police or a YOKO, and a lawyer such as myself, who have shown at least over the last few years that I'm interested in not helping to fight corruption, etc. Between the two candidates, who would you think would advance the cause of the whistleblower. So,
But if the lawmaker wanted a lawyer to be doing that, the lawmaker would have stated that. You know your interpretation of law.
All right, gentlemen, do stay with me. But another leg of this whole conversation, and from the NPP's minorities press conference, has to do with the caucus alleging that the Attorney General and Minister for Justice designate Dr. Dominic Ayine is deeply embroiled in a case of conflict of interest. At his vetting, Dr. Ayine admitted that some companies he represented as a lawyer in the past have commenced arbitration proceedings against Ghana, but insisted as AG he will always put the interests of the state above any consideration and that he is not conflicted. But the NPP minority disagree. According to Tano North MP, Dr. Gideon Boakon, who spoke on behalf of the minority, Dr. Ayine should not have accepted the appointment.
In the case of the Attorney General and Minister for Justice, the Honorable Dr. Dominic Ayine, it is clear he finds himself in a conflict of interest position. His law firm and he personally are representing companies that have filed arbitration claims in excess of over 500 million United States dollars. Can Ghanaians go to sleep believing that their money will be safe and that it will not be stolen through payment of dubious judgment debts, as we saw in the case of Wodiome? Ladies and gentlemen of the media, watch the space for GP, GC, and Cassius mining arbitration claims against the government of Ghana. In any serious country, we believe the Attorney General designate would not have accepted the appointment. Mr. Attorney General designate, why the public tribunal? What is our High Court not doing right, necessitating the creation of the public tribunal?
So that was the minority there at that press conference. Dr. John Darko is still with me. But first, we've been joined on the phone line by Godwin Eduji Tamaklo. He is a partner at Dr. Ayine's law firm, which is at the center of the NPP's case. Eduji, I'm grateful to you for joining us here. You've worked with him. First off, what makes him the best hand for the AG job?
Okay. So, once again, good evening to your cherished listeners. I just think that with the greatest respect to our listeners, the NPP minority are just engaged in political grandstanding. The issue that they have raised completely lack merit. There's no cause for concern because, one, the Honorable Dr. Dominic Ayine, now Minister Attorney General designate, the firm of which, like you pointed out, I am a partner with him. We have never represented GPGC as lawyers. We have never. In fact, as far as the arbitration matters are concerned, we were not the lawyers. Two, the award in respect of that arbitration has already been given. Now, to the extent that the award has already been given, what is it that the Honorable Dr. Dominic Ayine is going to do to reverse the award? You know what the NPP are engaged in? What you call gaslighting. You see, by now, key appointees of Mr. Akufo-Addo should be before police investigative bodies.
Well, Godwin,
hold on.
You'll get there. You can explain that. But has your company or your law firm represented Cassius Mining before?
So, at a point, we were lawyers, and this issue came up during the vetting. And the Honorable Dr. Akufo-Addo explained the matter properly. We were lawyers somewhere 2018, thereabout, for this company called Cassius Mining, until they took the brief away from us. Around 2021, 2022, thereabout. And since then, we've not had any engagement with them. In fact, the record will show that this company called Cassius Mining came before our courts here in Accra. The Honorable then Attorney General Godfrey Addo and a group of attorneys engaged them in our courts. We were not the lawyers. And this is over, if I'm not mistaken, over a year, 2 years now. And so for anybody to try to bring a relationship that had been, as it were, completely determined, parties have parted ways well over a year, and bring this matter up today is completely mischievous. Look, and let me say this. The Honorable MP for Swame, Darko, who had the benefit of the appointments committee to, as it were, get every clarification whatsoever as far as the relationship between the firm and Cassius Mining were concerned, had the opportunity now to use the platform of the press conference to provide completely misleading information and anchor that on a non-existent conflict of interest. It's regrettable, completely mischievous, and the end is purely to score cheap, very, very cheap political points.
Okay. I'm grateful. Let me bring in Dr. Darko here. Doc, you raised this issue at the vetting. How can he be conflicted when he, like Eduji has explained, they no longer represent the company? Again, he has explained that he will not be conflicted.
Well, I mean, my brother, we needed to bring this issue to the attention of the people of Ghana. It's interesting that the company in which the learned member of parliament, Dr. Ayini, represented, only brought this arbitration about 2 weeks ago. It's only interesting, very, very interesting.
Yeah.
Dr. Ayini, I respect him very much. He was my lecturer. And so when I'm looking at this, I look at it very critically, because I don't intend in any way to disrespect him or to disgrace him.
But if his firm stopped representing this company over a year ago, how can that be an issue now that he's an AG, even though they brought their rate, as you say, 2 weeks ago?
Exactly. In Cassius Mining, it was not just only his firm. He himself, the learned Attorney General designate, have written a letter defending the case of Cassius Mining, that they were entitled to over $400 million. He had written copiously. I mean, we need to.
When did he write this letter?
This letter was sometime, I think, 2021 or so, written to defend the claim of Cassius Mining.
But that is what Eduji is explaining, that they stopped representing the company long ago.
Let me make this point. So at the time he was writing this letter, at the time he was making this claim, he believed in the case of Cassius Mining. And then let's be careful as a country. NDC wins election. 2-3 weeks after, the company in which Dr. Dominic Ayini represented now filed arbitration at the London Center of International Arbitration. Now, do you know that when this matter goes to arbitration, that letter alone from Dr. Dominic Ayini, he acknowledged, he wrote that letter, about 2 pages or 3 pages. I read part of it at the vetting committee. That letter alone, when it's submitted to the arbitration, will be the end of Ghana's case, because he will be the Attorney General by the time this case goes to the London Center for International Arbitration. And they will tell him that you are now the Attorney General defending the Republic on this. Even at his best, when he wants to defend the Republic at his best, the arbitrators will tell him that you cannot approbate a reprobate. You cannot at one point say that these people were rights were breached and that they are entitled to $440 million. And now that you are Attorney General, you are changing your mind, even when you want to change your mind. And so,
but the Attorney General can decide. The Attorney General can decide not to represent Ghana. Get other lawyers to do so, can't he?
No. Okay, so my brother, you are missing the point.
Okay.
If he doesn't go, he is still the Attorney General, and the lawyers for Cassius Mining will present that letter to the arbitration committee. The Attorney General of Ghana, who is sitting at home in Ghana right now, he was our lawyer. He wrote this letter, and so he sent the people to now come and defend the republic. Look, you cannot approbate and reprobate.
Okay.
For us,
okay. I'm grateful to you. Let me bring in Martin Poiboya. Martin, you are in the middle here. You are a lawyer. Do you see any conflict of interest at play here?
So, what we can look at, on the face of it, no. But as I've always stated, look, we saw the last 8 years. So I'll be the last person to start gagging people. Lawyer Daku is an MP. I'm sure he knows how to activate other, facilities and institutions. Then he can dig further. They can dig further, and then we'll see if something good comes out of it. Even if something doesn't come out of it, it helps our democracy. Yes, so that's what I'll say for now.
I'm grateful to you, but before I wrap up, let me go to Eduji. Eduji, so, I mean, the MP, who is also a lawyer, still insisting that your boss is in a conflict of interest situation here. I mean, what should be the next step?
And I'll give you a classic example. In the first term of President Akufo, we started the prosecution of a man from Malam East. The firm that represented Malam East was Berry and Co. and was Berry's law. Subsequently, during his appeal, the Honorable Ambrose Berry, if you recall, became the Deputy Attorney General of the Republic. Does it mean that his initial representation of Malam East changed by raising? Everything must be looked on a case-by-case basis. Like I told you, this arbitration started right here in Cassius felt we could not represent them, their interests better, and went for a different law firm.
Eduji, I'm grateful to you for joining us here on Top Story, brought to you always by Telecel, Connecting Energies and Holy Insecticide Spray and Coil. Enjoy a holy sleep. Up next is Newsnight.